Oop. Hello. Welcome. Friday. Is it Saturday night? Saturday night. I guess that makes it all right. So what's happening, guys? This is I see Shane Souza is always here. You're so good and loyal. I'm impressed. My ever loyal mod, Shane Souza. I want to make sure I hope you're doing okay. Good to see you here. You're always here. It's amazing. I've got my pals here, and I had such fun last night. Didn't you have fun with Kaiser doing movie stuff? Yeah. So one of the things that people are saying, like, Gosney, you're this lawyer. We need to hear more lawyer stuff. And my lawyer content has dropped quite a bit. Occasionally, I'll appear on other people's streams, but I had a lawyer thing I wanted to talk to you about. And this is so I decided I'd put together a little stream here for y'all because for the law nerds, a little more civil, not criminal, and to get a little flavor of things. So let's see who we got here. We got Lily and Harlan and Snipe Hunter. Good to see you, Snipe Hunter. And Danielle's here, and Chuck Jr. Howdy. Defense Rest. Good to see you. Top of the morning. Fiery Red is here. Fiery Red, how you doing? Good to see you. So yeah, this is a little different stream. We just got done. My son and I are watching movies, and like I said, we've been watching B movies. We just got done watching Bram Stoker's Dracula, which was ridiculous. It's sort of campy movie, and then he wants, and we're gonna take the plunge, and we're gonna watch the prequels tonight. Yes, the Star Wars prequels. It's terrible. I just can't stand them. But the Red Letter Media did a whole thing on the prequels, which are great. And my son's never seen any of the prequels, so he said, "Let's just bite the bullet." My wife's not here tonight; she's off today. So I was like, "Let's watch it while we can," because the wife ain't gonna want to watch the prequels. And I don't know. It was so bad and shocking before. We'll see what it's like on rewatch. Maybe there's some redeeming qualities. I don't know. Anyways, but before we do that, and we're gonna have pizza, and he's leaving right now to get some pizza. Bella the Bayou's here. Good to see you, my ever loyal Bella the Bayou. Of course, my Rumbler, go Rumble. And yeah, big day coming up. Couple days, right, in DC. You know what's happening. But yeah, and one of you guys know that, or a lot of you guys know that I'm a big advocate for professionalism and ethical behavior in the law, and especially in the criminal law and prosecutorial ethics. I've written, in fact, one of my articles, my latest article, is getting a lot of downloads on SSRN. So if you want to go and research or look a lot of my articles on law stuff, you can go on SSRN and take a look. Kathy Trout, good to see you. So, but since I'm now over in civil, I'm trying to be, the same guy and be my own person and behave the way that to the highest standard. And I'll tell you, it's awful tough. There's some very difficult, nasty stuff going on in civil litigation. And I thought I would bring you all a little example just to see what you think. See what you think about this little interplay and how, and maybe just as an example, I want to throw it out there. I want to get your real life comments, your real reflections on what you think of the way this little dealie went down. And maybe there's better ways to do things. I don't know. I'm not sure what to do about these things. But let's see here. Present, share screen. Let's take a look here. I'm going to share this with you. Okay, so can you see that? Yeah, okay, so here we have, let's see if we can zoom in that in a little bit. Maybe, how do we zoom here? This is a link. I'm going to zoom that in. I wonder how I can do that. Link, comment. Anybody know how to zoom this in a little better? Maybe my comments can help me. Can you see that all right? I don't know. It doesn't look big enough. How do we zoom? Let me stop sharing for a second. Maybe up here there's a task. All right, let me try this again. Yeah, I know I need to zoom more. I'm working on it, Shane. I'm going to get there. I'll get there. Maybe this will work. I might do it there. Okay, editing. Zoom. Okay, that should be a little better. Thank you. Yeah, no rush, no problem. Share screen. Let's see if this is a little better. Is that better? Yeah, I think that's better. Okay, so here we've got a little, let's just use this as an exemplar. And what we have is plaintiff versus defendant, and the defendant is a driver, all right? So that's the story. We got a personal injury case involving a car, and we've got a driver here. Okay, so this is an example of professionalism, civil professionalism or unprofessional. I don't know. But here's the, let's look at the first things first, right? Okay, can you read that all right? So let's look at the first thing. Okay, and let's talk about the highest standards that we can hold ourselves to, right? Lawyers, we like to talk a big game and lay out what we think is important. And let's take a look at this. Chief Justice John Roberts of the United States Supreme Court said, as for the lawyers, most will readily agree in the abstract that they have an obligation to their clients and to the justice system to avoid antagonistic tactics, wasteful procedural maneuvers, and teetering brinksmanship. I cannot believe that many members of the bar went to law school because of a burning desire to spend their professional life wearing down opponents with creatively burdensome discovery requests or evading legitimate requests through dilatory tactics. What do y'all think about that? That's the Chief Justice. I think that's pretty good. What do you think? Okay. So let's keep moving and let's take a look at a little factual scenario here. So let's just say on a certain date, the court ordered the deposition of the defendant driver shall take place no later than January 31st, 2025. Right? Okay, so get that. So the first thing is this is what the court ordered. Deposition of driver can take place no later than January 31st. The date for the defendant driver the date that's for the deposition will be coordinated by the parties within the next 10 days. All right. Defendant shall provide plaintiff with dates to the effect the mutual coordination of the deposition by no later than December 23rd, as December 22nd is a Sunday. Okay. This is what the court is ordering. The party noticing defendant's deposition shall serve the same on counsel for non-party no later than 5 days prior to the deposition. Okay, don't worry about that. So do you understand what we have here? We got the court says the deposition must take place by January 31st. We're to coordinate the deposition within the next 10 days, and defendant shall provide plaintiffs with dates to the effect of mutual coordination no later than the 23rd. All right? That seems simple enough. How can lawyers screw that up? What do you think? You think lawyers can screw this up? Any ideas how we can screw this up? I don't know. Let's move. Let's keep moving here. So, on December 17th, 2024, okay, at 4:36, defense counsel immediately conveyed, this is the next day after the order, conveyed to plaintiff's counsel, January 17th is a possible date for the deposition. Got that? All right, so here's the order. Date shall take place no later than January 31st, and it'll be coordinated with the next 10 days. Got it? And so the next day, immediately after, defense counsel conveys, how about January 17th? All right, so that, and then just a few minutes later, plaintiff's counsel says he wanted 3 dates for the driver's deposition. Okay, I want 3 dates. December 17th at 6:50. Okay, so here's about an hour later, defense counsel says, is the January 17th date unacceptable? Plaintiff's counsel deflected the question, did not respond whether the January 17th date was acceptable. So defense counsel said, which date worked for you? Okay, this is all on the same day. So here's the dialogue. Okay, how about this for a date? January 17th. No, we need 3 dates. Is that not a good date? Conversation goes back, says, no, doesn't respond to that. What dates work for you, to plaintiff's counsel? Plaintiff's counsel deflected the question and refused to offer up alternative dates which he preferred. All right. So in response, on December 18th, the next day, defense counsel conveys 3 additional possible dates for driver's deposition, and requests they pick one of the dates provided. So the dates provided were the 14th, 15th, 16th, and then the 17th is still available. That's 4 dates, right? Now, what did the plaintiff's counsel wanted? 3 dates, right? Here, defense counsel says, how about 4 dates? So here's 4 possible dates, all right? So now that should solve the problem, don't you think? What do you think? Solve the problem with our coordination? Plaintiff's counsel failed to communicate if any of the 4 dates were acceptable or offer up alternative dates. So given the situation, on the 18th, defense counsel filed a notice of compliance listing the 4 dates of this deposition. Okay, so remember here, court order. The date will be coordinated. Defendant shall provide plaintiff with dates to the effect of a mutual coordination of the deposition no later than December 23rd. All right, so based on that C there, defense counsel says, all right, we're going to provide notice. We've complied by that and say we're going to give you 4. And since you're not responding, we're going to say to the court, we've complied. We've provided the 4 dates, right? Plaintiff's counsel failed to communicate if any of the 4 dates were acceptable or offer up alternative dates, right? So then they file this notice of compliance on the 18th. Following this? So on the 18th, after they provide the notice of compliance, defense counsel again asked plaintiff's counsel to select one of the listed dates for the driver's deposition. All right. Plaintiff's counsel again deflected the request and refused to offer up alternative dates, which he preferred. And there's 4 dates on the table at this point. On December 18th, 30 minutes later, defense counsel again asks for a date for the driver deposition. And on the 19th, at 4:13, plaintiff's counsel represented he would notice the driver's deposition later today or tomorrow morning. Okay, great. So on the 19th, we got the plaintiff's counsel saying, well, I'll pick one of those and I'll set it later today or tomorrow. All right, great. So on the 20th at 9:03 a.m., plaintiff's counsel repeated that he'd file the notice of deposition today. Great. Okay. So on the 20th, plaintiff's counsel reiterated he was eager to file the notice of deposition for the driver for January 15th. We finally have a date, January 15th, 2015. Okay, so we're going to get the depo. So they're going to notice the depo for January 15th. Great. No problems. On December 20th at 5:07, defense counsel agreed that plaintiff's counsel proposed date of 15th was acceptable and requested plaintiff's counsel notice the deposition. Great, 15th, you got it. Notice the deposition. At 5:15, so that's 8 minutes later, plaintiff's counsel responded with accusations of bad faith on the part of defense counsel and demanding the deposition take place on January 14th. What do you think about that? Interesting. All right. So defense counsel then replied at 5:21, right after that, asking plaintiff's counsel to set the driver's deposition for the 14th. Okay. You want the 14th instead of the 15th? It's up to you. It's on the table. Go ahead, set the date for the deposition. All right. The driver, this is a good question. Driver's flexible. We're trying to offer up these dates. Okay, now this is in December for the end of January, so things change. As things fill up and schedules, it's tough to hold up 4 open dates for a deposition if you're in a firm. But okay, so first it's like, okay, the 15th is acceptable, notice the deposition. And then there's a rant and say, no, we want it on the 14th. Okay, great. Set it on the 14th. On December 20th, plaintiff's counsel failed to set the deposition of the driver. At 7 o'clock, again asked plaintiff counsel to set the deposition. Now look at this one. Over the next week, plaintiff's counsel failed to notice the driver's deposition on any of the proposed dates, forcing defense counsel to hold open several days in January when scheduling demands required that time in other cases. All right? Following this? So now I will tell you, holding open 4 dates for a whole week is very difficult. All right? When you've got, and that's within a few weeks, okay? Instead of noticing the deposition, plaintiff's counsel busied himself with multiple filings, cluttering the court's docket, attempting to utilize the dates supplied by defense counsel for his own motions that he's scheduling purposes. Look here, docket items 141, 144, 145, 146, 147, 140, 148, 149, 150, 150. These are all docket items filed by the plaintiff that he's trying to get set on the dates provided. Are you following this? So now we're running out of time here. On December 26th, due to immediate demands on defense counsel's schedule, and in compliance with the court's order of the 16th, defendant driver noticed the deposition of the driver for January 17th at the office of the court reporter. Okay, see, now what's significant about the 26th? Well, back here on the court order, if you remember, the date for the driver shall be coordinated within the next 10 days. The 10 days ran out, and the plaintiff had never set the deposition date, hadn't noticed it. Get it? And then notice the party noticing defendant's deposition shall serve the same on counsel for the non-party no later 5 days prior to the deposition. Okay, so this doesn't say who's to notice the defendant's deposition. So it's like, okay, if this plaintiff doesn't want to set it and he's using all these dates and not conferring and doing everything else, then go ahead and set it for the 17th, which was the original date that we offered up. Okay? Okay, within 15 minutes, plaintiff's counsel noticed the driver for a different day, time, and place. You following this? What do you think? Okay, so let's just stop it right there, and I want to see what you all think. I mean, first of all, civil's not as interesting as criminal. But what do you think about this little scheduling dust up here? Does this sound like something that you want to go to law school to engage in? Is this kind of gamesmanship something that we should encourage? Does this look like good faith behavior? Well, what do you think? Trish Norman says that's some BS. Which party here is trying to get things done, and which party is doing the obstructing? Michael Stetson's here. Good to see you. Amazing disgrace. It's funny. It's a funny thing. Okay, so let's take a look at what do you do about this stuff, all right? There's something called Section 57105 of the Florida statutes. All right, 57105 is a sanctions statute. And you don't really like filing these things because they're generally an unfriendly act in lawyer world. But with this kind of hassle, do you think it's warranted? Well, I don't know. Let's read the statute. At any time in any civil proceeding or action in which the moving party proves by a preponderance of the evidence that any action taken by the opposing party, including but not limited to filing of any pleading or part thereof, or the response to any request by any other party was taken primarily for the purpose of unreasonable delay, the court shall award damages to the moving party for its reasonable expenses incurred in obtaining the order, which may include attorney's fees and other loss resulting for the improper delay. Okay, do you think that these actions, do you think there's a sanction here? Do you think there's something sanctionable? Well, we have a civil proceeding, right? Assume that the facts in that little dialogue are true. So that would be preponderance of the evidence, proves by parties. So the defense counsel would have proved that. Let's assume that you can do that. Those are true facts. And that any action taken by the opposing party, in response to any request by any other party was taken primarily for the purpose of unreasonable delay. You think that's why this was being done? Why do you think this was being done? Yes, see there, it's Snipe Hunter is sniping for right. Trish Norman says she's for sanctions. It's warranted. Okay. And then the damages are basically the attorney's fees and dealing with it. All right. Now here's another little twist to 57105. Is generally 57105 requires notice, a 21 day safe harbor provision, but that safe harbor provision provides for corrective action. So you have to give the other party 21 days to correct the bad behavior. But in this case, there is no bad behavior. Hey, T-Rex is here. Good to see you, T-Rex. T-Rex trucking. All right, so now you've only seen one side of the story. Is that fair? I want you to, are you guys following this? This is complicated. See, civil is not as fun as criminal because the complexities, these little interactions, they don't seem as exciting. When you're in the weeds and you understand it, it's interesting, but it's not as sexy as criminal cases. Okay, so I'm gonna take that down and we can see, like, I want to take a look at what the plaintiff says, right? Because obviously something like that's filed, the plaintiff's going to have a side. There must be another side. So let's be fair on this channel, and let's take a look at maybe portions of what the other side, how they may practice. It seems one side's being a really amazing disgrace. Yeah, well, who's being the bully here? Well, do you think that pleading there was abusive? Do you think that recitation of facts was abusive, or was it a factual recitation and asking for remedy? I don't know. This is for your. This is, again, it's a puzzle for you as my loyal viewers to try to figure out if you think that this is something into the practice of civil law, not criminal law. All right, let's take a look at this. So this is this is portions of the plaintiff's response. All right, can you see that? Yeah, this is why costs go beyond what most people can afford. That's true. It's not difficult to set a date. Yeah, that's true. 3 sides to every story. Well, I don't know. Maybe, maybe not. Let's take a look. Edited for public consumption, all right? But it's not edited. It's deletions, not editing, changing the words. This is what an actual lawyer filed with the court, and this is very typical of what the lawyer tends to file in court. All right. Here it is. As usual, plaintiff will take the high road and simply speak the truth with real facts in a professional manner while backing up the accurate history with hard evidence. Herein under is the irrefutable truth. How do you think that lawyer, is that a lawyer speak? Okay, I don't know. However, to short circuit the instant response up front, plaintiff simply reminds this honorable court of the old axiom from Carl Sandburg. If the facts are against you, argue the law. If the law is against you, argue the facts. If the law and facts are against you, pound the table. It appears that this is precisely what's going on here today with the instant case. Additionally, before getting into the underlying facts and or true and accurate events heretofore, or the spiteful nature of driver's meritless motion, plaintiffs states upfront that defendant's highly problematic motion is legally deficient and needs to be stricken as a matter of law. How do you like this start? Okay, well, let's see. Is there substance behind what he's saying here? I don't know. Keep going. Let's plunge ahead. Quintessential example of hypocrisy on its face! Exclamation point. Additionally, the precise moving party who just filed the subject 57105 motion blatantly ignored the strict 21-day safe harbor notice and instead chose to prematurely run to the courthouse to sling mud and be awarded some sanctions money. Yes, the same party who baselessly argues about compliance to rules and professionalism, with gripes about unnecessary motions clogging up the docket, is indeed 100% guilty of the precise conduct of which they falsely alleged. Hence, hoist with his own petard. Even the actual face of driver's motion patently fails to even recognize that a 57105 motion strictly requires a safe harbor notice as a condition precedent. Not even a 21-second good faith notice was furnished, just a surprise attack by driver who engaged in demonstrably bad faith conduct. Simply stated, driver has no business, basis, or legal grounds whatsoever in filing their inherently frivolous 57105 motion. So, unfortunately, here we are again with defendants pointing the finger without regard to for the applicable laws or rules or history. Above all, conduct that illustrates zero respect for plaintiff's time, as she, along with the underlying counsel, are compelled to expend valuable time to remedy defendants' sham and frivolous motions or cure their repeat blunders. To add insult to injury, someone is collecting attorney's fees, profit, for engaging in all these shenanigans. Accordingly, by way of the instant motion and the court's inherent power, the plaintiff hereby seeks the financial sanctions driver wrongfully sought to obtain and finally put an end to this utter nonsense. What do you think so far? How do you like the going a little overboard with the hyperbole? Yes, this is an exact response, including the misspellings, the wrong capitalization, and the wrong punctuation. This is exactly what was filed. Okay. So and no, it's not a she. This is a male lawyer. The plaintiff is a she. Okay, so let's keep plunging ahead, because maybe there's some facts here. Right now, you read the facts about the reason for the complaint by the defense counsel, right, which was the scheduling conflicts. So let's see if we get to that. Let's see if there's any rebuttal to that or any kind of explanation of what might be going on. I don't know. Let's keep going. True underlying history with specificity in the full context. Okay, well, good. We're going to get to that now. On February 7th, 2024, what is that? 10 months ago? The senior legal partner and managing shareholder of the subject defense law firm sent the undersigned plaintiff's counsel an email wherein the lead defense counsel stated, "Plaintiff's attorney, thank you for your professionalism. That's very rare these days. I expect to look forward to working with you." Okay, so what is this? The plaintiff's counsel is attaching an email from 10 months prior where the defense counsel said, "Thank you for your professionalism." So one of their defenses is that the defense counsel said, "Thank you for your professionalism" 10 months prior in an email. That's exhibit number one. What do you think? Are you persuaded? See, defense counsel's called him professional, so he must be professional, right? Although this case could and should have been resolved pre-suit, defendant went radio silent for months after plaintiffs graciously and voluntarily sent defendants a comprehensive packet of her medical records. Defendant expressly confirmed receipt and then later falsely denied receiving the medical receipts or emails. Plaintiffs had to prove that it was indeed sent, received, and even acknowledged as received. After proof of electronic transmission was produced, defendant failed to issue any sort of apology for their internal issues. Okay. Okay, I don't really know what that has to do with the present situation, but there it is. Okay. However, after 7 months of laboring on the above captioned matter, and specifically on December 6, 2024, so now we're talking about September. This is October, November, December. On this precise case, all of whom work in conjunction with the same defense firm also sent an updated comment wherein the associate attorney wrote, "Plaintiff's counsel, it was a pleasure speaking with you today." So exhibit 2 for the defense of plaintiff's counsel is that at one point 4 months ago, an associate said, "It was a pleasure speaking with you today." So there you go. Okay, so that's exhibit 2. Are you convinced that he's acting behavior? Okay, so let's see. Now we have this bunch of subheads here. Defendants claim they're somehow too busy to schedule anything, but evidently have plenty of time to file one scandalous motion after the next. As a sideshow to the motion of January 6th, that's the one I just showed you, they want to be financially rewarded for their own inactions, conduct, and problems that they themselves put in motion. What do you think? Okay. It goes on and on. Even the plaintiff were to give opposing party the benefit of the doubt that the underlying conduct is not intentional, but the result of too many aggressive defense attorneys working the same firm on the file, or failing to communicate with another, or just human error. We are still equally concerned that their internal blunders, errors are causing significant collateral and damage on a systematic basis. I don't even understand what that means, but there you go. After plaintiff filed objections to defense's defective suit, per the rules, they went behind plaintiff's back and tried convincing a non-party to just ignore the timely objective to give them a full. Defendant defamed plaintiff via sending a highly improper emails with outrageous allegations rising to libel. On the other hand, undersigned professionally responded and stated plaintiff will take the high road. So what do you think? This is, how did I discover this? Is circulated between professionals. That's what we're doing right here. Wait, this is so poorly written. Non-justified margins document was, it's a lot worse. I've cleaned the formatting up, because actually the text is all different sizes. It's like a serial killer pasting stuff. I've cleaned it up quite a bit for your consumption here. This was filed and this is, believe me, this is not just a singular. This happens all the time. Yeah, libel, right? Well, obviously, you said it must be. Defendants are essentially all one and the same party, working concert together before and during this litigation. Yet these folks just represented to the court that they somehow don't have position, blah, 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 their own. Hence, pure game amounting to legal gymnastics, or simply put, nonsense. Once again, falsely claiming this highly relevant and garden variety item is somehow not in their possession. This is something, does that have to do with the scheduling? I don't know. At the outset of this litigation, plaintiff asked over and over to coordinate mutually convenient times and dates for hearings. Not only did defendant refuse to respond and repeatedly blew off plaintiff, but then turned around and unilaterally set their own items for hearing with total disregard for all the professional courtesies extended to them. In fact, defendants even moved forward on one hearing ex parte without having actual knowledge. Plaintiffs on the phone trying to connect with the court. I'm not even certain what that is, but anyway, there it is. Does that have to do with the scheduling issues complained of earlier? I don't know. The bottom line, okay, we finally got the bottom line. Defendant's groundless motion of the January 6th raises to a textbook definition of hypocrisy. Defendants have engaged in significant amounts of kick the can, dilatory tactics, and other shenanigans from the pre-suit through this action, while plaintiff has been extremely patient with defendants. This includes, without limitation, extending professional courtesy after professional courtesy. Virtually all emails asking for defendants' cooperation even state, please cooperate. So because plaintiff's counsel puts at the end of all his emails, please cooperate, that must mean he's just trying to get along, right? Okay, right. Yes, seeing just allegations, only one. Yeah, the exhibits are, remember, the two emails that were sent months ago saying, thank you for your courtesy. We're eye-rolling each other's to death. Hey, J.K. Buck, good to see you. All right, so I don't know how much of this you can take, but let's keep plunging ahead. On December 30th, the court wisely urged the counsel to advance the client's interest in an efficient manner as opposed to fighting. Okay. Unfortunately, from recent January 6th filing, it does not appear that all players have heeded the court's prudent advice. Since the court's smart advice provided by the court, defendant has demanded instant gratification in their items via making a huge fuss or stink over trivial items, and continued to engage in a temper tantrum over irrelevant collateral issues just to be unnecessarily difficult. Filing of motions to strong arm and intimidate the plaintiff with an utterly sham 57105 motion is clearly inconsistent with the court's recommendations. Moreover, the filing of the woefully unfounded and legally deficient 57105, wherein defendants insist on rehashing old business because hearings rulings don't go their way, via highly derogatory, inflammatory, and scandalous remarks concerning plaintiff's counsel, crosses the line of decency and speaks volumes of what's truly going on here. I'm adding a little dramatic, written by Ted Kaczynski. This is pounding on the table. And I was going to say, here, T-Rex, isn't the court trying to place where we're supposed to fight so we don't murder each other, right? Okay. And when their own problematic motion invites an accurate reply, it results in more unfounded complaints about the high amount of docket entries. Defendants could and should have used the time to comply with outstanding court orders or merely cooperate with plaintiff, making a bona fide effort to work together on time-sensitive discovery objections or discovery motions. In summary, if banging on the table does distract from the fact that you don't have the law or facts on your side, please make a desperate move to personally attack plaintiff's counsel's character, even though you praised his professionalism before he exposed defendant's sham pleading, which contained fictional cases. See Schutzpah. So, okay. So, I believe me, I edited out about a few more pages of similar type stuff. So, what is your impression? Just weighing the. I hope I'm not. That will be. I hope I'm giving a fair hearing to Mr. Plaintiff here. Because a second, let me present. Let's go back and let's just take a peek, just real quick, and just remember. Let's look at what this pleading is responding to. Okay, we've got the Roberts. Here's what Chief Justice of the U.S. Supreme Court. As for the lawyers, most will readily agree in the abstract they have an obligation to their clients, the justice system, to avoid antagonistic tactics, wasteful procedural maneuvers, and teetering brinksmanship. I cannot believe that many members of the bar went to law school because of a burning desire to spend their professional life wearing down opponents with creatively burdensome. All right. And here we have a simple order on the court. Schedule this guy's deposition in the next 10 days. Okay, now what does the defense pleading say? This is the sanctions motion. December 17th. Hey, how about January 17th for the driver's depot? I want 3 dates for the driver's depot. Is December 17th not good? Did not respond whether the December 7th or the January 17th was acceptable. Well, which dates work for you, plaintiff's counsel? Would not offer up alternative dates. Okay, fine. Here's 3 more dates. So now you have 4 dates. Pick one. Plaintiff's counsel fails to communicate any of the 4 dates are acceptable or offer alternative dates. So the defense says, okay, we've complied with the court order. We've got the 4 dates. Let's file that. Defense counsel, after the filing, says, select one of the dates for the driver's depot. Deflects the question, fails to offer alternative dates. Defense counsel asks for a date for the driver's deposition. Please, give us a date. We got 4. We got the scheduling demands here. I'll notice the deposition later today or tomorrow. I'll follow it down. Then the next day, I'll notice the deposition today. The next day, I'm eager to file the notice of deposition for January 15th. Oh, we finally have a date. January 15th. Great. So defense counsel says, okay, 15th is great. Notice the deposition. And then you get plaintiff's counsel responding with accusations of bad faith on the part of defense counsel and demanding the deposition take place on the 14th. So defense counsel says, okay, set it for the 14th. Go, notice it, do it. Failed to set the deposition. Hey, set the deposition on the 14th like you said you were going to do. And then it took 1 week, filed all of these docket items, and didn't set the depo. And so finally, defense counsel set the depo on the 24th or on the 26th. And they set it on the January 17th. So what do you think, folks? This is my this is a little lesson in civil hell. Let's see what you guys are saying here. I wouldn't have sent an email to a colleague that had that tone and word choice. Just what do you think about the word choices between these two pleadings? It reminds me of writing email after too many drinks. Yes, that's right. Hell hath no fury like a woman called unprofessional. This is a male plaintiff's attorney. These are men on each side of this. This is don't blame the fairer sex for this one. So did they ever say why there wasn't a date set? Maybe I missed that. No, there was no reason given at all. It's just don't want to set it because, well, the real reason is the plaintiff wanted to set. He filed all those other motions and there's like 10 other pleadings and wanted to use every date on that calendar to schedule all his hearing dates on all his motions that he files. So he wants to keep those dates open so he can file all these motions and just keep the plaintiff's or the defense counsel's calendar open. Stuff's coming in, there's like, it's like not the only case for defense counsel. It may be the only case for plaintiff's counsel. I've been there, done that. Hey, good to see you, Mads. Thanks for being here. And the answer is yes. The depo did happen on the 17th. So anyway, that's my little story for the thing. But what do you think about the motion? Do you think that warrants sanctions, that behavior? What about the wording of that pleading? I don't know. I'm just thinking it's kind of interesting. There might be more in the wings on hearing from our favorite plaintiff lawyer to see what kind of. I mean, could you imagine writing that stuff and putting it in writing to the court? I'll tell you, in appeals, that would not go over for a second. When I was doing appeals, that echo the word salad that's put in there, and the crazy adjectives and the all I'm good faith and the bad, all the cringy. Yeah, that's a good word. I mean, cringy. I don't know. This was my genius stream for tonight. I thought it was kind of entertaining. More sanctions because of plaintiff's word salad. Yeah. Warren's a good talking to. He's all about that. So yeah, that's the problem, because there's no sanction, right? Unless there is a monetary sanction, then plaintiff gets away with it, right? That's sort of just abuse and word salad and incoherence and not addressing the thing. That is a do they get away with it? And do judges get worn down and say, okay, everybody just stop fighting? Is there everybody fighting, or is it just one side? I don't know. Amazing experience. It was fun to listen to. Maybe fun to listen to, but when you're in these battles like that, it's not fun. By difference, I thought I graduated high school. Yes, it's a high school. It is. It's like playground behavior, right? I will tell you, I'm making a very strong effort in my civil practice to be a good attorney. Now, I can say when you're dealing with this kind of stuff, it's hard, and you have to resort to sterner measures, right? But in my civil practice, I don't think that you need to be like that. I don't think that that's required. I think all that does is make everybody miserable. And I think I have a few plaintiffs lawyers that I'm working with right now. Now I'll shift over to my put my Gosney hat on, and maybe my appeal to my civil brethren is that we're going to disagree. I'm a defense counsel. You're a plaintiff's counsel. You want money from my client. We won't agree on the law. We don't agree on facts. We don't agree who's responsible for what. And yeah, per my last email, yes, that's exactly right. And so I'm trying to be, and I have a few plaintiffs counsel that I love, and some of them are just professional, right? But my objective is we're here to resolve things and to work together, and we're in the same boat. We're trying to work together to resolve these issues. And so if I can make it pleasant for you, then I'm going to do that. And I'm going to extend as many courtesies as I possibly can. Yeah, you don't need to be like that at any time. I hate poor sports. Yeah. And so I have one place, and we're going to go to trial. I think we're going to go to trial first week in February. And I said, whatever you need. And we disagree on the law. We disagree on the facts. Okay, well, if we disagree, we have a verdict form, and we disagree on the verdict form. Okay, no problem. I put my proposed verdict form and you put your proposed verdict form. We have plaintiffs, we have defense, and then we let the judge decide. And if we come up, we can't agree on something. Okay, let's agree to disagree. We'll have a hearing. You object to timing, no problem. Put it in a motion. We can still be courteous and friendly to each other. And I think it is incumbent. Oh, my pizza's here. So anyway, that was fun, wasn't it? Yes, the truck. Oh, that was scary. Yes, the truck. We have not identified the truck. And but I have another way of doing it, and I'm going to pursue it. I will keep telling you about the truck, and hopefully we'll identify it. But pizza's here, and Lily, you thought that was interesting. What did you think about a little insight into the civil world? Maybe I'll bring some more for you. Yeah, we should video bomb. We should find. Let's see if who's streaming. Anybody know who's streaming tonight? Maybe we can do a. Maybe we can do a. What do you call it? Those Gosney raids. I love it when you guys do that. Thank you for Nagati. So hang out first. Let's see if we can find a shucks. Okay, hold on. This always takes a second. Anybody who's live streaming that we can send you over to? Yeah, he got some pizza. We brought it in. Got water, Stephen? Okay. Let's see. Content. Let's see. Oh, you just did the cellulite. Just came in like you can go back and watch. I got a lot of good content, and a lot of the stuff I did does not necessarily involve. It doesn't involve like time. So I interview some really neat experts. Redirect. Here we go. Add. Let's see. Search videos from other channels. All right, here we go. I'm gonna find it. I'm gonna redirect. Let me find. I like redirecting. It's fun. And remember, you got to do the thing, right? What's the thing? Winning reality. So T-Rex wants winning reality, and baby goats are always good. Let's see here. Got to do something. Who would people appreciate? Now this is not right. Winning Reality's got 12. We got Baby Goat Thunderdome and Winning Reality. Okay, we could do Winning Reality. Let's see here. Paste. Okay. All right, we are ready to go. Now, when you go over to Winning Reality, what are you going to do? God's raid, right? All right, so we're ready to go. Hey, have a good night, and thank you all for being here and support. Thank you for people who YouTube members. That's cool. That's nice, and you're encouraging. As long as I've got people out there who want to hear what I have to say, I'm still going to try to keep coming. Monday's coming fast. That's right, Shane. So we are rocking it, and so now I got to go and watch the prequels. Right. So we'll see. Okay. Oh man. All right. What are you gonna do? Okay, you're gonna say Gosney raid. All right. Good night, guys.